All right, part 4. Setting aside a default or a default judgment. The court may set aside an entry of default for good cause, and it may set aside a final default judgment under Rule 60B. Judgment against the United States. A default judgment may be entered against the United States, its officers, or its agencies only if the claimant establishes a claim of right to relief by evidence that satisfies the court. Arthur Roosh, presiding judge on the habeas, was not allowed to dismiss and deny a default judgment motion in the state habeas. The petitioner's conviction of second-degree escape is void because the state failed to file the return within the time for doing so. No request was made for an extension of time or delays. The judicial officer, Arthur Roosh, presiding over the habeas, mind you, he became a senator after this. They promoted him to senator after they stopped this case, and Jerry Miller got promoted too. They like to promote people when they violate your rights and they get away with it and they cover each other up. They promote themselves. State of South Dakota, that was Dennis Doggard, that was the governor at the time of this stuff. And Kristi Noem's the governor now, and she ain't trying to do nothing either. They're both pieces of shit. The judicial officer, Arthur Roosh, presiding over the habeas corpus hearing on his own, allowed the delay solely on the unconstitutionally vague grounds for good cause without stating the reasonings or what the good cause was. Jerry Miller failed to return service of the writ, and it began a practice. Not only were the South Dakota state courts on notice, but prior to informing South Dakota state courts of the misconduct and malicious prosecution, the United States federal district courts were previously informed in District of South Dakota Civil Case Number 094142. State habeas petition was dismissed on March 1st, 2010. Rush entered his order on the day of the hearing instead of later due to the false claim that petitioner was flat-timing his sentence in a few weeks and the petition would become moot, making false and misleading statements and falsifying the court's records. See Exhibit 1, Document 2. Petitioner would not discharge until April 4th, 2014, not in March of 2010. And he did that knowingly. He had knowledge. He had intent. Therefore, the petition was not going to be moot in a few weeks, as Arthur Roosh fraudulently and intentionally distorted the facts. Not only that, the quorum nobis was, even if I was, the quorum nobis is for when your sentence is done. It's the same thing as a habeas corpus, only you're not in custody, you're already out. You're still challenging the conviction. Petitioner was in fact only being transferred and concealed in Minnehaha County's Jameson Annex Unit C minimum security prison, still held in the custody of the Department of Corrections and the state of South Dakota in violation of South Dakota Codified Law 21-27-11, transfer or concealment of applicant to avoid habeas corpus writ as a felony. Petitioner corrected Arthur Roosh on the habeas corpus record and explained that he was not flat timing and his claim that I would be completing the sentences were mistaken, and Roosh intentionally disregarded the petitioner's statement and the fact. He disregarded the fact. Arthur Roosh, acting judge, entered his order of dismissal on the record. The petitioner informed the courts that he wanted to appeal to the Supreme Court and filed an application for court-appointed counsel, Exhibit 1, Document 8, and was appointed Philip Peterson of Stewart, Peterson, and Rumka Law Offices, a member of the bar on the 22nd day of March 2010. Appeal was subsequently quashed due to them transferring me again. They transferred me to some military base to fill sandbags. They declared a disaster. Dennis Doggard declared a disaster when I filed this. They declared a disaster, and their remedy to that was the disaster. It wasn't the flooding. The disaster was me filing that petition. Philip Peterson intentionally deprived the petitioner of his Sixth Amendment right to the effective assistance of counsel for my defense in violation of Title 18 U.S. Code 241-242, deprivation of rights and conspiracy against rights. By deliberately withholding his professional legal assistance, defective and ineffective court-appointed counsel refused to file the appeal and somehow caused the appeal to become quashed on April 27, 2010 by violating lawyers' professional conduct and duties to client. South Dakota Codified Law 16-18-A. South Dakota Rules of Professional Conduct, Exhibit 1, Document 9. I'm Gomez. Gomez, at all times during the habeas corpus process, was in custody at the South Dakota State Penitentiary during Peterson's appointment as counsel for the habeas proceeding. Petition did not cause the appeal to be quashed. The attorney refused to draft and file the appeal on behalf of the petitioner. That's dereliction of duties and breach of fiduciary and a deprivation of a Sixth Amendment right. Years later, petitioner was accused of several crimes and demanded trial, which cases were eventually dismissed for lack of a crime, lack of witness, and or lack of evidence on several occasions, resulting in the defendant filing a complaint against the state of South Dakota, the Minnehaha County State's Attorney's Office, the Public Advocate's Office, and the Public Defender's Office. Employees in United States District Court for the District of South Dakota, Gomez versus Minnehaha County State's Attorney's Office, et al. 420 CV 04151, Appendix D. Due to the repeated Part 2 information habitual offender allegations for the deprivation of rights under color of law, deprivation of the Sixth Amendment right to a speedy jury trial, the continued ineffective assistance of court-appointed lawyers, and the refusal of those attorneys to assist the defendant in any way have a speedy jury trial as required by the Constitution. Court-appointed counsel have customarily only ever attempted to discourage client from going to trial and obtain guilty plea confessions on behalf of the state. When the lawyers are defending police, domestic terrorist police, and other domestic terrorist government officials and human traffickers, then the effective assistance is clearly demonstrated by the lawyers. See effective assistance example by reviewing the level of vigor Woods Fuller law firm provides for defendant Ritter and Bobier, accused domestic terrorists and human traffickers. Attorney Mark Cady misled petitioner, leading petitioner to believe the state did file Part 2, as did other named attorneys, Tim Hirschberger, Caleb Paulson, and others, including Michael McGill, regarding habitual offender statutes, and misrepresented facts to petitioner in an attempt to obtain an involuntary plea of guilt to criminal allegations, stating, if you plead guilty, they will drop the habitual offender enhancement, or if you don't plead guilty, they will file the habitual offender, and then you will be facing more time. Now, at any points where they're discussing any defenses, they weren't scheduling depositions, they weren't calling witnesses in to give sworn statements, they weren't doing none of that. They come in there and talk me into, well, they offered this, they offered that. I'm not talking offering. I want a trial, and I told you that over and over and over. How many times did you come back offering different plea bargains? That's duress. That's coercion. Petitioner informed his court-appointed counsel that he was not making any admissions of guilt and that he was demanding a speedy trial over and over. And they got it recorded in the county jail's video cameras. You could read my lips. And unless they had the audio on, you could play the tapes. That's evidence. Those cases were dismissed against the Sixth Amendment right to a jury trial. The facts are that no habitual offender information had been filed in any case. Therefore, the state did not dismiss any habitual offender allegations as they were not filed. Well, they're confusing me again. I guess they did file them. Minnehaha County State's Attorney never filed habitual offender enhancements. That's what they said in 420-041-51. That's what the Robert Lang is his finding of facts. And it's not true. He found that fact. It's not true. I got the document right here. They did file it. Robert Lang, whatever the hell her name is, dismissed the complaint against court-appointed lawyers, Melissa Summers, Mark Cady, Tim Hirschberg, on the basis that they were not persons acting under color of any statute law, Appendix D. The court committed error in its assessment that defense counsels are not persons acting under color of law for purposes of Section 1983 civil complaints. Defense lawyers do, in fact, act under color of a law, specifically South Dakota Codified Laws, Chapter 16-18, Powers and Duties of Attorneys. See Exhibit 1, Document 9. Rules of Professional Conduct. All defense attorneys for petitioner at some point in separate cases that were dismissed after demanding trial to the attorneys, my own defense lawyers were advising me that I was facing life in prison if I went to trial and lost. So I'm not getting punished for the crime. They're punishing me for exercising my right to go to trial. That has a chilling effect, doesn't it? Not too many people are going to exercise their rights when they're threatened out of it. You're waiving your rights under threat. Because habitual offender was a factor, the same thing Michael McGill did, the habitual offender enhancement was not even a legitimate factor in that case. All lawyers misstated, misrepresented in a conscious attempt to intentionally mislead petitioner to believe he was charged with the habitual offender charges, or made motions falsifying that petitioner was requesting new counsel and motioning the courts to remove them from assisting me, causing delays unreasonably. That's not a reasonable delay. I never told you to quit. I told you to do your fucking jobs. Excuse my language. But I'm exercising my freedom of speech. Further depriving the petitioner of Sixth Amendment right to lawyers' assistance and having an adverse effect on speedy trial rights. Violating them.